Peter, you may kick off.
Sorry. Good morning, everybody. My name is Peter Leroux. I'm an executive consultant in the Department of Employment Law at ENSafrica. Welcome to our pop-up webinar that we've entitled Coming Out of COVID, in which I will act as chairperson or moderator. And we all hope that you'll find this pop-up webinar interesting and instructive. During the last 2 years and a bit, employers have had to operate in the challenging environment brought about by COVID. We are probably very happy that the state of disaster has been lifted, but the problems remain. The mere fact that we no longer have a state of disaster on the books does not mean that our operating environment will be rule-free when we deal with COVID. There will be rules in place and will probably remain in place for a long period of time and will probably change as COVID changes itself. The purpose of this webinar is to provide attendees with an overview of these rules, some new, some old, and these rules will be there to regulate how you fight COVID in the workplace. Our panel to discuss the new legal regime consists of 3 very experienced labor lawyers. They are Stuart Harrison, Joe Matibe, and Lawrence Salt. There will be opportunities for attendees to pose questions or to pose or make comments. You can do so by utilizing the question and answer button on the screen. We try to limit the length of our pop-up webinars to approximately 1 hour so as to minimize disruption to your activities at work. We have a lot to cover, and I will turn to our panelists immediately. The first panelist will be Lauren, and she will be dealing with the various documents or sources that you will have to consult when deciding how to act and combat COVID-19 in the workplace. Over to you, Lauren.
Peter, thanks. So I'm going to talk to you not just about what happens going forward, but where we've come from. There have been a number of regulations that have been promulgated in the last few months, and I think largely have left everyone confused about what's still in, what's out, and what's going to happen in the future. So everyone would have known that during the course of February and March, we had some pivotal alert level regulations coming out. We had some amendments to the alert level regulations as recently as the 22nd of March. We then had a draft amendment to those alert level 1 regulations come into it was promulgated for comment. And now we've got a revised version of those that it's come into effect on the 5th of April. So what that really means for you is that you can disregard everything except for the 5th of April Alert Level 1 regulations. And those are the regulations, as the President would have told us in the announcement, that will form the transitional arrangements for the next month. So that is where the alert level regulations stand. Now, those are not the only regulations that we need to take heed of during the course of the next few months. We've also got new Hpe regulations, the Hazardous Biological Agents regulations, and these are things that are not new. So we saw a new version of the Hpe regulations come out in February of this year. They are revised regulations of the initial ones that came out in 2001. And obviously those weren't fit for purpose and didn't deal with the exact nature of the COVID-19 pandemic. So they've been upgraded slightly. There's been no real change, and we won't be focusing on those regulations too much today, but they are something that you will need to be alive of when you are looking at hazardous biological agents in the workplace, one of which is COVID-19. Now, the most pivotal change for you as employers is going to be the changes relating to the consolidated direction. So this is a document that we've seen in various iterations over the pandemic, and the most pivotal one came out in June 2021, which dealt with, among other things, mandatory vaccinations. Now, what has happened with the termination of the state of disaster is that that document has fallen away completely, and it has been replaced with a new code of practice on managing COVID-19 in the workplace, which is promulgated in terms of the labor relations legislation. So we'll be definitely talking to you about that, and Stuart is going to elaborate on that code, and so is Joe. Now, the last piece of legislation that is relevant, but maybe not so much as at the moment, is the NHA regulations that are due to come out. You will have heard the President say that the reason we've got these transitional arrangements relating to the alert level regulations is because we've got draft National Health Act regulations that need to be finalized. Now, those came out for comment, and we'll be talking to you briefly about those today, but they haven't yet been finalized, and they'll only probably be finalized towards the end of this month and maybe early next month. So that is something that you guys will definitely need to look out for, as it does replace some of the alert level regulations that we've come to know. So just to sum up, we are not rule-free going forward. We don't just have these transitional arrangements in place. What the government has sought to do is to disperse some of the very well-known regulations that we've come to know during the pandemic into other sources of regulations. So we'll now need to keep our finger on the pulse on those various pieces of legislation to make sure that we are managing COVID in the workplace properly. Peter.
Thank you, Lauren. Lauren mentioned the code of practice, and this document, I think, will be central to our the way in which we operate in the workplace from now onwards. Stuart, what do you think the status of this code is, and how will it be applied?
Thanks. Yeah, as Lauren mentioned, the first point to note, I think, is that it's a code that's been issued under the Labor Relations Act. Now, that might seem counterintuitive a bit when you hear that, because this is about health and safety primarily. You say, well, why isn't it issued there? And is it permissible to do that under the LRA? So the relevant section there, which is section 203, does enable the minister to issue a code of good practice that deals not only with issues relevant to the Labor Relations Act, but issues relating to other employment laws, any other employment laws, as long as the code says that it does so. And this code says it, that it's intended to apply to and be taken into account in the application of all other employment laws. So it's a strange source, maybe a counterintuitive source, but a legitimate source under which the code has been issued. So then what's the status of, what's the legal effect of this code? So, well, the code itself says it's a guide to employers and employees in managing exposure to COVID in the workplace. You say, well, will be intuitive to all of you who've worked with codes of good practice issued under the LRA and the various other pieces of legislation, some sort of a guide, not prescriptive, not necessarily mandatory, but a guide. So happy days, no problem with that. This code tries to go further than that, I think, in some of the language that it uses in relation to its application. So first of all, it says it has another purpose. Apart from being a guide, it has a further purpose, and that is to require all who work with a code, and it lists employees, unions, employers, inspectors, arbitrators, conciliators, judges, to take into account the code when interpreting any employment law. Now, that again is not a surprising concept that codes of good practice should be taken into account when applying other employment laws. But I think they're making quite a point in this code to say those actors around this code, including judges and arbitrators and inspectors who are dealing with enforcement, you are required to take this into account when you're applying employment law. And if that wasn't enough of a sign, they go beyond that. And interestingly, this is a code of practice, not a code of good practice. And I think that might be a sign that this is, good practice sort of indicates, this is sort of, what we would like to, have as first prize. I think a code of practice is saying, this is what you must do, guys, and not something that's just some, you have a choice about. The code goes on to sort of reinforce this, and just in case the minister thought the message wasn't getting through, includes a section that says, to the extent that this code advances an interpretation of the law, that interpretation is the policy of the minister and the department and should be applied unless that interpretation is reversed by a decision of the courts. Now, that's a pretty strong, and I've not seen that message before in another code. A strong message to, I think, the enforcers of laws, health and safety laws around COVID, and I'm thinking particularly about inspectors, but also courts. Say, if you want to know what the policy position is of the minister and the department on these issues, this is it, just in case you are in any doubt. So it's quite clear what the messaging is, we expect compliance with this code, even though it doesn't have its own independent binding legal force. So against that background, you say, well, can I depart from this code? Because that's the usual questions. It doesn't always suit everybody to do every single thing in the code. Again, that's been anticipated in the code. There's an explicit provision there, which says, apart from the provisions of this code that reproduce obligations contained in employment laws, and that's an important qualifier, which I'll return to, the code is intentionally general because workplaces and their requirements differ. Accordingly, departures from the non-obligatory provisions, I come back to that, of the code may be justified in appropriate circumstances, but if an employer or an employee wants to depart, then they must demonstrate justifiable reasons for doing so. So what does that mean in practical terms? It seems to me that if in applying this code, when you're dealing with your obligations, which will be unpacked further just now, you want to depart from the code. First question you've got to ask yourself is there an aspect of the code from which, sorry, I'm inevitably getting calls during presentations. Is this aspect that I want to depart from an aspect of the code that reproduces an obligation in some other employment law? And the obvious other places are OSHA, Hpe Regulations, and depending on what is finalized, maybe these draft or these National Health Act regulations. If it's replicating, reproducing an obligation under those laws, then I can't depart from it, because that would mean I'm contravening those other laws, of course, unless those other laws allow you some leeway. So if it's one of those aspects of the codes that replicates another law, an obligation, then you can't depart from it. If it doesn't, so if it's something that's not regulated by one of those laws, then there's scope to depart, but then you need to have good reasons and you need to be able to demonstrate those justifiable reasons for doing so. So I think that's the analysis that I would undertake if you reach a point in the code where you think, I don't want to do that, or I don't think that's applicable or appropriate for me, before you can decide whether to depart or not. So if you don't comply with the code, then what? So the code itself is not a source of penalty or enforcement consequence. Its status is not a regulation. It's not a piece of legislation. It does not include provisions that say if you don't comply with this code, you commit an offence and you incur a penalty. That it does not do. But of course, if to the extent that it replicates obligations on those other laws, and they provide for penalties and consequences and offences. So, and we know OSHA does, we know the Hpe Regulations do, the National Health Act regulations might do as well, that if you then don't comply with that, then you're going to face the offences and penalty consequences under those laws though. And when they're deciding under those laws whether you've complied with those obligations, they're going to take into account this code. So it sort of feeds in through the application and interpretation of those other laws that include the penalty and offence provisions. So a contravention of this code per se does not automatically follow that you've committed some offence or that you will incur some penalty, but you must read it against the other pre-existing laws. Interestingly, I think on enforcement, the code includes a specific provision, not allowing, but referring to the fact that the minister may delegate enforcement powers under powers he already has under OSHA to local authorities. There's anticipating, that they might need some capacity assistance with the enforcement and application of the code and the laws that sit behind it from municipal officials. So you might not get an inspection from a Department of Labour inspector to check whether you're complying. You might get it from a local authority official who, assuming the minister then delegates properly and under his powers and under OSHA. So that you might be surprised by who knocks on the door, I guess, to check whether you're complying with the code. It might be somebody you're not expecting to see. So, I think that's the basis of the source of the code. So, in summary, it doesn't have force of law on its own. It's not a law that your compliance can be measured against, but it's likely to substantially influence the interpretation and application of the other laws which are mandatory: OSHA, Hpe regs, and the Health Act regulations when they come into force, if they come into force, and quite frankly anything else, dismissals, discrimination, all of those things. To the extent that the code hits on those, it's going to substantially influence, I think. So depart from it as a measure of last resort would be my advice, and check before you depart whether it's in that scope of aspects of the code that's not a reproduction of another law, and then make sure you have a very good reason for departing. That would be my general approach to sticking to the code or departing from the code. Thanks, Peter.
Thanks, Stuart. Joe, what is clear is that the code is much shorter than the consolidated direction. Does this mean that some issues have fallen by the wayside? Can you deal with that issue, please?
Yeah, no, thanks, Peter. I think that's right. The new code is generally a lot less granular in detail. So insofar as what's fallen off, I suppose one of the more important aspects that we picked up that seems to have, or that has fallen away, is the requirement for screening. So the requirement used to be you've got to screen your employees as they come in, as it were, if I can paraphrase. But now what seems to have happened is that the obligation is flipped. So the employee is required, an employee who shows symptoms of COVID and is COVID positive has an obligation to report that to the employer. So that's the one that I've picked up and that we've picked up. I think it's an important one, in that it's no longer the employer who must screen, but the employee must report that. The obligation to report will be dealt with under your risk assessment plan as an employer. And I think linked to that would probably be contact tracing, but I think I'll move further. I would be moving further from your point if I go there. Yeah.
And the other issue, Joe, is what has changed with regard to isolating, or people? Are they required to isolate, and if so, when? Can you give us some idea there?
So the requirement currently, or rather, let me say, the previous requirements on isolation in the previous regulations have fallen away. The current requirement under the code is that you must still isolate, provided you are COVID positive and you show symptoms. You must obviously also have informed your employer of those symptoms. Interestingly, under the period there is not stipulated, but other than to say the period recommended by the Department of Health, which for practical effects remains the same. It's 7 days if you're positive and show symptoms, and there's no requirement in respect of asymptomatic patients. In respect of the health regulations that will be coming in, the requirement is similar in that you must be positive symptoms, and then you isolate in accordance with the period recommended by the Department of Health. And I suggest that that period will still be 7 days if you're symptomatic. Peter?
Thanks. One of the burning issues we have been confronted with in the last few weeks is what will the position be with regard to masks? When will they have to be worn, if they have to be worn at all? Stuart?
Yeah, Peter, so it's interesting. I always gauge when you have a regulatory change like this.
Yeah.
What's the question that people most ask? To see what's the most influential practical issue in their life. And for me personally, in terms of the queries that I've got, it's been masks. As soon as Cyril stopped speaking, my phone just buzzed with, does that mean we still have to wear masks in the workplace? I think it's what lots of people find one of the biggest burdens. So I mean, before April, we knew mask wearing mandatory indoors. And if you didn't comply with an instruction to wear a mask from a police person, then you committed an offense. More recently, not mandatory outdoors. We always enjoyed that couple of weeks of having to not wear it outdoors before this change came. So national state of disaster ends on the 4th of April. General alert regulations fall away, as Lauren's indicated, but they keep a couple of residual regulations on for a month to last then for a month from the 4th of April. And one of those relates to masks. And I think it's pending or in anticipation of the finalization of the National Health Act regulations, amongst others. So for this month period that we've just started after the announcement of the end of state of disaster, the position is that that regulation 67 from the general alert regulation survives. So that's mask wearing mandatory in indoor public spaces, except for kids under 6. Not allowed to use public transport into public buildings, government buildings, etc., without a mask. And for employment law purposes, that express obligation that an employer can't allow an employee to perform duties or enter the premises if they're not wearing a mask while performing duties. So that is still with us. So it's still masks in the workplace for this month period. So then what happens when the month expires? And I do think it seems to me that the National Health Act regulations are not going to be in place by the time the month expires, because the comment period only expires, I think, on the 15th of April or thereabouts, and thereafter they've got to still finalize and issue. So what does the code say? So the code doesn't expressly and directly say mask wearing is mandatory, but it says when you're doing a risk assessment in your plan, you must deal with, amongst other things, personal hygiene measures. And the example expressly cited is such as the wearing of face cloth masks, and then the additional stuff, barriers, hand washing, sanitizers, all those sorts of things. So I think that risk assessments for most, if not all, employers are likely to conclude that face masks are necessary as a measure to mitigate the risks, even though the code hasn't said thou shalt wear a face mask, as that there's no qualification of it. I think the risk assessments are going to drive to that conclusion anyway. So that's just under the code. Under the draft National Health Act regulations in their current form anyway, they deal with what's going to happen in indoor public places and masks being required, and public transport. That's all seems to be the same. And then in relation to employment issues, it just says an employer must provide employees with a cloth or shield face mask to cover his or her nose and mouth, which you can kind of read as being that's what that's going to be required for employers to enable their employees to wear masks. And then under the HPA regulations, the new Hpe regulations, the employer has got to take standard precautions to reduce the risk of transmission in the workplace. And they expressly say that they may include, amongst other things, face protection, protective clothing, respiratory protective equipment. You're obliged to introduce measures for the control of exposure by the suppression of emissions of an airborne HPA like COVID. So I think that even though that express imperative that was in play has gone, in effect, I think a proper application of your risk control is going to require, for the foreseeable future anyway, face masks to be worn in the workplace. And who has to provide the masks? That consolidated direction had been explicit to say you've got to give 2 face masks to employees. That's obviously fallen away. It's not carried over into the code. Those draft National Health Act regulations say that, as I've mentioned, the employer must provide the employees with a cloth or face shield. And under the HPA regulations, you also got to provide appropriate protective clothing, which I think is probably going to mean, in effect, that you must provide masks still. So I think, unfortunately, for those who find mask wearing constricting, they're going to be with us for the foreseeable future.
Thanks, Stuart. Joe, Stuart touched on the issue of the enforcement of the code, but there's still the issue of the compliance officer, or the requirement of the compliance officer. Does that still exist, or has it been done away?
So in the new code, there's no mention of a compliance officer. In fact, there's no requirement. But interestingly, in the draft regulations, there is a requirement for a compliance officer insofar as social distancing is concerned. So the short answer is that currently there's a lacuna or a gap between the new code, which doesn't require a compliance officer, and the coming regulations, which would require one specifically on social distancing. Peter, with your leave, I just wanted to deal with one question. I see some people could not hear me. I hope they can hear me. We just ask that you log in again so that you can, if there are any problems with sound. Secondly, there is a question about isolation, which I think is an issue I dealt with previously. And as I said, the question is whether you need to go for isolation if you're only displaying symptoms associated with COVID. The requirement under the code is that you must isolate if you are diagnosed with COVID and show symptoms. So I'd be interested to hear from my co-panelists on whether, if you're only showing symptoms, whether that also would, in their view, whether that would bring in the requirement for 7-day isolation. I don't know if Lauren has any thoughts.
Lauren, do you want to comment on that?
Yeah, Joe, I mean, I think you've identified that the code says what it does, but I think there would obviously be concerns for employers if you've got someone coughing their lungs out at the entryway to your premises, that you don't necessarily want them coming in until there's some kind of confirmation. So I think you'd certainly be able to, if someone is symptomatic, require them to go and test. And I think the code does provide for that. It said the employer may require an employee who's presenting with symptoms to go and test. So you may want to, in any event, impose a precautionary isolation as the employer.
Thank you. Any other comments from the panel? Thanks.
I agree with that, Peter. I mean, I think my experience on these sorts of things is that one's got to err on the side of conservatism when people are presenting with symptoms, even though they're not positively diagnosed, because the consequences are too grave potentially to be robust about it. Would be my suggested approach.
Right, thank you. We've got some interesting questions coming in. I will, however, ask Lauren just to deal with this. But when Stuart pointed out that we've been pestered by calls and dealing with whether we must wear masks or not, the other issue deals with vaccination. Can vaccination be compulsory, and if so, when? And for that thorny topic, we turn to Lauren to discuss.
So similarly, after the president spoke, I had countless WhatsApp messages from clients saying, what about our mandatory vaccination policy? Will it survive? And following that, I've received further calls from clients saying, we've got employees knocking on our doors saying, we're not going to vaccinate now, and your policy is now unlawful. So let me just take a step back, because obviously when we talk about mandatory vaccination, it comes from somewhere, it comes from our risk assessment. So the new code requires you still to undergo the very self-same risk assessment that you would have done under the consolidated direction, taking into account your OSHA obligations and your HPA regulation obligations. So you still have to do that. There's a question I see from Mtimkulu Mashia on that point. He says, if I did a risk assessment under the consolidated direction, do I need to redo it? If nothing has changed, the answer to that question is no. But obviously risk assessments are live documents. Risks are constantly changing and you need to evaluate if your risk assessment is up to date. So if things have changed such that you need to update your risk assessment, you should be doing that without any further obligations being imposed on you by any laws. So in respect of the risk assessment, if your risk assessment says that you are at risk and you then can impose health and safety measures to mitigate that risk, one of them can still be mandatory vaccinations. So the good news is that the new code still recognizes mandatory vaccination. For the most part, it is very similar, except for one glaring change. And that glaring change relates to the refusals. So you'll know under the consolidated direction, it says that employees could refuse on constitutional and medical grounds. There was a very specific definition of what those constitutional grounds were. It was the right to bodily integrity and the right to freedom of religion, belief, opinion. And then there was a very specific definition of what medical grounds were. Now, there was also a whole diatribe about how we needed to balance the constitutional rights out, and there was a strong emphasis on constitutional rights. Now, in the new code, there is a dearth of that same diatribe. There's no mention at all of constitutional grounds, and there's no qualification of the refusal. So it says an employee can refuse to be vaccinated. Not an employee can refuse to be vaccinated on constitutional and medical grounds. So what the new code seems to do is to blow open the refusal gates, as it were. And an employee can now seemingly refuse on any ground. Now that does become a little bit contentious, and it's probably a topic for another day and probably a whole dedicated webinar. But effectively, that is the primary change, that now you need to look at the refusal. If it's on any grounds, you seem to need to then counsel the employee, and then the code says take steps to accommodate that employee. So now we're sitting with a situation where potentially an employee could object on any grounds, and then you need to look at accommodating that individual. Another change in relation to the refusals is where you've got a medical refusal that you've accepted. So you've accepted that the refusal is valid. Then you must accommodate. And interestingly enough, there's no qualification of accommodation there. So it doesn't say you must reasonably accommodate. It just says you must accommodate. So that to me suggests that potentially, even if it's going to cause you some sort of hardship, you're going to have to accommodate that employee with a good medical reason. So those are the key changes to the mandatory vaccination environment. Anyone who's got a mandatory vaccination policy at the moment is probably well advised to have a look at their grounds of refusal, any processes that any objection committees might be going through in how they are evaluating what they will accept and who will qualify for accommodation and who won't. And that process might need rejigging slightly, but you can certainly still have mandatory vaccination policies in place, and they definitely aren't unlawful.
The other topic that sometimes comes up is the issue of gatherings. What's changed there, if anything, with regard to gathering?
So as Stuart mentioned, there was a few provisions that are in these transitional arrangements, mass being one and gatherings being another. So there is a definition of gatherings which certainly seems to me to include a whole lot of recreational activities, ones that we've been used to seeing in the gatherings regulations over the pandemic, dealing with sporting events and religious gatherings and conferences. And then there's the imposition of certain restrictions dealing with the distinction between vaccinated and unvaccinated persons who attend. Now, those are what the president was talking about in his announcement earlier this week. But there's certainly nothing in any of the other legislation that suggests, to me at least, that the gatherings regulations are going to survive the transitional arrangements. So currently where we are at the moment, if you've got gatherings in the workplace, you are still permitted to have those gatherings under the transitional arrangements. There should be no real impact for employers between now and post to the transitional period, because nothing will really change in the workplace unless you are organizing gatherings which fall within that criteria. So for the next 30 days, you have those limitations that have been imposed on us in terms of capacity.
Right. We've got several interesting questions that have been posed. The first deal, the 2 or 3 of them deal with the issue of the reporting of COVID-19 cases or symptoms and that type of thing. What are have they fallen away completely?
So I'm happy to take this question. And so they have been taken out of the new code. So they've not survived the change between the consolidated direction and the new code. But what is interesting is that the National Health Act regulations still suggest that there must be a maintenance by government of this contact tracing database. So there does seem to be some obligation somewhere, and how that might fall is not necessarily clear from the national code. It might be broader obligations to that might come out of all of this, that people must report their own symptoms, but it's certainly not an obligation that's falling on the employer anymore.
Right. Any comments on that or issues from my panelists? I think it's dealt with. The other question that I find intriguing, to what extent will employer conduct be judged in terms of the new code for actions taken prior to 4 April? What is the relevance of this documentation, of these new documents, the new rules with regard to actions of an employer prior to 4 April?
Yeah, I mean, Peter, I don't think an employer is going to be held to account against these newly framed guidelines or semi-mandatory directives in the code. You can't. It's a core principle of law that you can't be held liable retrospectively for complying with rules that didn't exist at the time. So I think up until 4 or 5 April, your compliance is going to be measured against the then existing consolidation direction, then existing HPA regs and alert level regulations, and that you'll only be tackled on this code and its impact on other statutory interpretation from now. So you've got, I think you've got, as Lauren's indicated, there's a sort of exercise to undertake of now revisiting your plan and risk assessment against the code to see whether it needs adjusting. And my sense is that the enforcers of the code and laws will allow employers the opportunity to do that and not expect you to have woken up on the 5th of April and immediately complied with a law or a code that only came into operation that day.
And maybe just to jump in on that point, it's something that we have seen over the course of the pandemic. As we've seen various iterations of, for instance, the consolidated direction come out and people being terminated or otherwise in relation to those provisions, the court has taken that into the account, and so has the CCMA. So that should be some comfort to employers who are a bit worried about their past conduct.
Yeah, if I can come in there, Peter, as well, I agree with everything that Stuart and Lauren says, but I think as employers, we must always bear in mind that the health and safety is the paramount overriding requirement or thing that we should look out for. So it's a work in progress. This is completely new and uncharted territory. So it's a work in progress. We must always look at it, and where necessary, where it may be necessary on occasion to do tweaks. But certainly, I agree with what Stuart and Lauren have said.
Yeah. I mean, I made my other general comment, Peter. I mean, you've seen it's admittedly we haven't had anything completely authoritative and decisive, but on the matters on mandatory vaccination that have come before arbitrators and the like, the general approach has been pro-vaccination, pro the public need for health and safety, and the need to compromise individual rights to enable public safety. That's the general sentiment that I've seen in the awards that have been given and people in authority. There's still fights to be had, and they're still coming. I mean, I know that amongst just on these panelists, we're all dealing with legal challenges to mandatory vaccinations for different clients. So we haven't heard the end of the story, but the general approach so far has been, I think, in favor of, and I don't see that changing materially under the new code and regulations, in favor of vaccination as a legitimate public health measure that intrudes upon individual rights to an extent, but as a reasonable intrusion. I think that's still going to be the general approach, is my sense.
I suppose it may also differ or change in time, depending on what scientists say with regard to the efficacy of vaccines and that type of thing.
Yeah, absolutely. Always subject to the science.
Yeah. One interesting question is what we talked about enforcement of the code. In what context will it come before the CCMA? How will the CCMA deal with it? Is it unfair dismissal, unfair discrimination cases?
I guess it has the potential to feature in the dismissal cases. So the thorny question that Lauren alluded to of the refusers under the new code and whether or not a refusal can legitimately lead to a termination, and if so, on what grounds, that issue, which is a dismissal issue ultimately, which will come before the CCMA in more instances than not. The code will feature there, I think, prominently in the assessment of fairness by the CCMA. But I mean, otherwise, it's not that the main enforcers is the Department of Health, Department of Labour, sorry, on OSHA, Hpe Regs, Department of Health to a degree on their own regulations. And as I mentioned in the code, it may be that the minister delegates enforcement authority to local authorities and others to try and increase the capacity to police this. But I think my sense is that that's the main space in which enforcement will play a role, but it'll feature in the CCMA on dismissal matters. On discrimination matters, I guess those are mostly going to be in the Labour Court rather than the CCMA as a general proposition, but I suppose for the low earners or by agreement, it could be before the CCMA, would be my sense.
Yeah, I wonder what will happen. Will an employee be brave enough to come and say, well, by forcing me to wear a mask or get vaccinated, you are making continued employment intolerable and unlikely, but I mean,
it would be in my view, it would be a brave employee because I think at the moment the likelihood of that case succeeding, I think, is quite low.
Yeah, I agree. Any comments, Joe?
I mean, I think mask wearing. Sorry,
Lauren,
Joe.
I was going to say I agree with Stuart. I mean, it will be a very brave employee who brings that case forward. Sorry, Lauren, go ahead.
No problem. And it's just off topic, Joe. So thanks for jumping in. I mean, I think for me, when we talk about mask wearing and an employee coming to say that, it says may in the code, so we don't necessarily need to wear masks or arguments like that. Employers must always be guided by what their risk assessment says. So if your risk assessment says that there is low risk, then you need to adjust your measures accordingly. If your employees are working at home, you don't necessarily, despite what these transitional arrangements suggest, that an employer can't let anyone work without a mask on. You don't need to require your employee to work with their mask at home. So you need to assess what the risk is and adapt your measures accordingly. So when you get before the CCMA and someone challenges the need to wear a mask, that it is underpinned by your risk assessment and the justification for needing to wear a mask.
Another question is,
if I can say, Peter, sorry, just on that, I mean, at the risk of repeating what I said previously, but I mean, ultimately, it's about health and safety in the workplace. You know, you don't just have these rules for the sake of it. So Lauren's point is spot on, or example is spot on. You don't wear a mask, there's no risk that you will transmit it because you're just simply working alone and at home. So one must always be alive to the reasons why these measures are here. They are aimed at ensuring health and safety. Thanks.
An interesting question dealing with the question I asked, is tracking and tracing still required? And if so, when?
I think we've dealt with that question.
Okay. I didn't, but yeah, fine. Let me just see. I'll read the question again and make certain. I think I may have done the questioner a misfavor there. And then another more general question is, have we had time to sort of to digest what the new regulations will be in terms of the Health Act, and are there any acts, any omissions or any things that you don't agree with or which you have concern about? Does any, for the whole panel, is there anything like you can consider there? What is wrong with the new code or the new regulations? I know people have criticized it, but I'm not certain on what basis yet.
The one thing that certainly stood out for me was the suggestion that there still needs to be working from home. So in the provisions that deal with social distancing, and let me perhaps find them for you quickly, but you know, I think everybody thought that our days of working from home were over. But there does seem to be a suggestion in the National Health Act regulations that it says here that all employers must adopt measures to promote social distancing of employees. Fair enough. Then it says which measures may include the following: enabling employees to work from home where necessary, or minimizing the need for employees to be physically present at the workplace where necessary. And I think this for me comes out of that very well-known line to many employees out there in the alert level regulations that said where employees can work from home, they should. And so this seems to be a survival of that sentiment. And, you know, for me, it was a little bit counterintuitive with the return to work type of provisions that we were seeing with the mandatory vaccinations in the consolidated direction. Stuart, yes.
Yeah, I mean, I was also thinking, is it not, you know, for the employee who suffers from like a trifecta or more of comorbidities, and is at the highest risk you can be, and who is perfectly able to do their job from home, that it's those sort of extreme cases, which I think in practical terms, it's probably very few people in that position, but those where the risk to the individual is massive, and there's no impact on the ability to do the job. It's those sorts of scenarios where working from home is a measure to look at rather than everybody else.
But for me, that was then better placed in the new code. You know, not under the social distancing requirements under the National Health Act. Seems to me a bit counterintuitive that the National Health Act does deal with some employment related things when I think probably they should have been included in the code. But I can certainly see many employees are going to be latching onto that line if it survives the draft.
But I mean, my view is that even though it survives the draft, I mean, ultimately we're talking here reasonable accommodation. So it can't just be, I want to work from home, therefore I am going to work from home. No, we look at the operational needs of the employer, the peculiar circumstances that the employee faces from a health perspective, and see if we can live with each other, as it were. So it's not a carte blanche, I don't think.
Yeah, so I mean, that raises also an interesting question that I see is on here, which is also about reasonable accommodation, is the cost of COVID tests as accommodations. Stuart, you're smiling there. You want to give us your view?
No, I know your view is this is an employer cost in virtually all instances, and I guess other than when you get to, you know, if it's the case under the code that the nature and validity of the reason for refusing is relevant, which is a debate in itself, whether, and if it is relevant and the reason is a terrible reason and a completely indefensible reason, and there is an alternative of PCR testing, that the employee should bear the cost of that. I mean, I guess that's the argument for employees bearing the cost of a test, the sort of best argument, but that otherwise it's an employer cost to be undertaken as part of its health and safety obligations to minimize risk in the workplace.
Yeah, I mean, this is a tricky one, and one I grapple with, particularly now the new code has come into being, where it's blown things wide open, and you've got to ostensibly look to accommodate people who are just being belligerent. So, I mean, historically, I certainly think that if it is a reasonable accommodation, what our disability law says and where we sit with the primary health and safety obligation, we should be looking to pay for COVID tests unless it causes us unjustifiable hardship. And that will obviously be on a case-by-case basis. What is a justifiable hardship for one business might not necessarily be for another.
Yeah.
Yeah, sounds right.
So yeah, it's certainly harder to know the answer with the blandness of the new code on what sort of refusal is any refusal good enough. Just because I refuse, is that okay and I must be accommodated, or must there be an underlying valid reason? I mean, that issue is going to have to be thrashed out and determined at some point too, because it has knock-on consequences like this.
The other question that comes up, which I find quite interesting, is what about sanitizing? Is that still in the code? Is it now discretionary, or is it a requirement still?
My sense of that falls in the same space as all the normal, hygiene measures. That I certainly mentioned in my answer to some of the earlier questions. That amongst the things that you have to consider as whether or not it's a reasonable measure would include hand washing and sanitizing. So, I mean, and again, I would be very surprised if a risk assessment concluded anything but sanitizing. There needs to be sanitizing facilities and in place as a risk mitigator. So I think in practical terms, it's still going to be a necessary measure to mitigate risk.
Yeah,
No,
and
I sorry, Lauren. I was going to
no,
say.
go ahead, Joe.
I agree with that. I mean, I think previously it used to say you must sanitize, but nothing is that you may. But it's a suite of measures that you must look at in mitigating risk in the workplace: mask wearing, sanitizing, and the like, social distancing as well. Sorry.
Yeah, no, absolutely, and so I think, whilst there is a softening of the language in the new code, I don't necessarily think we will be able to escape these measures as the outcome of our risk assessment, as Stuart has said. But another thing to mention is just in the draft Nha regulations, as they stand at the moment, it says that every business must have hand sanitizers at the entrance of their premises for employees, and I think it says the public to use. So that's certainly, if it does survive the comments process, will be an obligation.
Linked, another question that links to this is the idea, and what one of the questions is can you address the issue of an employee's ability to refuse to go to work or to do a certain type of job because it exposes the employee to COVID-19? Can the employee refuse to work if there is such a potential exposure?
Yeah, so that provision has survived the consolidated direction, and it's made its way, unfortunately so, into the new code. It's certainly, in my experience, one of the most abused provisions in the consolidated direction, and I think it will continue to be in the new code. But Stuart, I can see you've got some comments.
No, I'm agreeing completely. It's there. When I was paging through the code for the first time while holding my breath that it hadn't featured, but there it was. Yeah, I mean, it's for the people looking to cause trouble. It's the easiest space to cause that trouble, because it's quite onerous under the code as to what you must do with the employer in dealing with it. But unfortunately, it's still there, so you still have to mud wrestle with that.
Yeah.
The next question, I think we may have dealt with tangentially, is who pays for COVID tests?
We've just dealt with that, Puck.
Just
No, but I mean, the point
No
is,
further comments.
okay, fine.
No further comments. Can of worms.
Yeah. I think that's all the questions we've got. Anything else that people want to address?
I mean, I did see a question, but there was on vaccination, and does it mean fully vaccinated? Does that include a booster?
Yeah.
And Lauren may be able to help me there. I remember reading it somewhere in one of these.
Yeah, so
these
they've
regulations
changed the
that it does.
definition. They've changed the definition. Well, no, maybe they've not changed it. They've introduced a definition in the new code. That's that fully vaccinated means you're having your 2 shots of Pfizer, 1 shot of J&J, and any boosters that then you become eligible for. So that's something to consider. I know that during the pandemic, there was a lot of debate about whether or not in your mandatory vaccination policy you include boosters or not. I think some people were a bit reticent to do so because there was a little bit of confusion as to whether it was actually necessary or not. So this seems to rubber stamp that you can certainly ask for boosters in your mandatory vaccination policy.
Interesting. 2 people are arguing or raised the issue of incapacity. Is incapacity a ground for dismissing somebody who refuses to be vaccinated under mandatory vaccine policy? Quite a vexed question, I think, but you and I have discussed it. Lauren, what do you think?
Well, I think we need to deal with the mandatory vaccination stuff in a full webinar. I mean, there's certainly instances, and probably more often than not now, where you're going to be incapacitated by your refusal.
Yeah, I mean, I would say, I mean, it's in principle possible, I think. I mean, there's difficult debates and issues about whether somebody who's refusing should be how they should be dealt with, whether they should be dealt with through an incapacity exercise, because it, depending on how you deal with them, you know, the obligations differ, or is there a basis upon which there can be a misconduct termination? And that is a difficult exercise and made harder by the code and what it says and what it doesn't say. But it's certainly in principle. I think it would be possible with the right facts to terminate for incapacity for somebody.
Yeah, I mean, I agree with that. I mean, you're required to try to explore reasonable accommodation in various scenarios, and where you cannot reasonably accommodate, I think, in principle, that reason for termination can arise.
Right. I see our time's almost up. Is there any comment from any of the panelists about issues that have come up or you've thought about during the question and answer session that you want to address or deal with? I find it interesting that tracking and tracing is a requirement. It seems to be an impossible task in the first place. But it'll be interesting to see how that's applied.
Yeah,
Right.
so I think we'll only know the answer to that once the National Health Act regulations have been finalized, and if we see any more obligations there.
Yeah, so,
Right.
so I guess those National Health Act regulations are open for comment at the moment. So those employers who see things in there that they envisage being hugely problematic from a practical perspective, and I guess, Lauren, as to your point as to, is this the proper home for regulation of employment related obligations in a National Health Act regulation, that those sorts of representations can be made until, I think, the 15th, if I'm not mistaken, of April. So if it's a real issue for you, get some representations in. I'm fairly cynical about what impact representations have on these things, but you don't know if you don't try.
The final question, which I'm not certain my panelists will be happy that I'm asking, is it legally permissible to separate vaccinated and unvaccinated employees in the workplace?
Yes.
Why?
So, I mean, I think it's quite a tricky question to navigate, because obviously it deals with discrimination. But I think in circumstances where you've got an obligation to accommodate people who have refused to vaccinate, then one of the suggestions has always been isolation. So if you are isolating the vaccinated people to a specific area, I don't see that you're going to have an issue justifying the differentiation. I see Stuart nodding and Joe nodding. Come on, guys.
I wanted to say something if I could. I mean, I'm not as definitive as Lauren, but we do know of employers who only allow into their workplaces vaccinated people. And if you're not vaccinated, you're not allowed in. So I think using that as a basis, one can certainly, I think, argue that there could be separation, but obviously it must be justifiable and rationally justifiable for that. That's all I have to say. I'm not as definitive as Lauren.
Yeah, I mean, I agree. I think it's in principle permissible with the right facts, but I think it's an employee relations problem. You know, it's a separation that is going to cause employee relations issues, regardless of its legality. That's the challenge. And that's why I think lots of employers have resisted it. Certainly the ones that I've dealt with have resisted doing that because they know that it's going to create an us and them environment, which can be unhealthy depending on the size of the unvaccinated group, I guess.
But I think with the right set of circumstances, those employee relations issues can be mitigated. So if you've made a separate station for those people who are unvaccinated who need to come in and print, but they're working at home most of the time. I mean, I think there's certainly ways to mitigate that, and you might find that if it means that they are left to their own devices and don't have to be vaccinated, they might be all too happy to be put in the basement.
But I think we all agree it must be based on the science. You can't just, it must be based on the science, the reasons why you're separating the two. It has to be, I think.
I think we need a mediator to sort some of these problems out. We're dealing with strong characters in the Department of Employment Law, and I may have to arbitrate one day on this issue. Any further comments? I see we run out of time, but any other quick comments or questions from the panel that you want to raise?
I think the one thing to emphasize is that this is not going to be the only coming out of COVID webinar that we're going to have. We're going to be dealing and unpacking as we go along all of these issues. So that for those of you who've still got some unanswered questions, keep your eyes peeled for our next seminar. It may be answered there.
Right. Thank you, panel. I enjoyed listening to your answers and the debate you had. And thank you also to our attendees. I hope you enjoyed it. I hope you found it instructive. And until next time, goodbye. Thank you.